Hi there, can everybody hear me? I'm just setting up this live stream from my office, and I'm hoping you're all well and doing well over there. My name is Liora Lazarus, and I am a law fellow here at St. Anne's College, along with my colleagues Antonius Zanakopoulos and Imogen Gould. And my area is in the area of human rights. I'm also head of research at the Bonavero Institute of Human Rights, and have been teaching human rights there for a very long time. My work is generally speaking, in security and human rights, and my interest for a very long time has sat at that interface. So the reason I'm talking to you tonight is because in my capacity at Bonavero, I have been leading a research report on human rights and COVID-19. Let me just go back a step so I can explain to you why I think human rights is a useful way to think about the process of how we can balance between binary oppositional views on the COVID-19 pandemic response. So on the one hand, we have the view that negative rights, in other words, the rights to liberty and to freedom, to property, require the state to stay away from us, not to intervene, not to take away our freedom and our liberty. And on the other hand, we have a different conception of rights, which is the positive conception of rights, which requires the state to act to secure our rights. And those are the rights to life, and in other constitutional contexts, the rights to health and access to health, which you see in a number of different jurisdictions. Now, the right to life requires the state to take positive action to secure the citizens of its countries, or the people in its territory, if you like. And in doing that, the pandemic is one of the classic examples of where the state has to act in order to secure the health and lives of its people. Now, this is why the human rights response to a pandemic may be seen as something that is not one-sided. And in a way, what I call the stereoscopic view of rights, which is being able to look in both directions at the right to life and also at the right to liberty. This COVID-19 pandemic is a classical case of how this operates. So how many politicians and oppositional voices have been speaking in the last while has been to talk about ending the lockdown, or to bring more freedoms to us. We have people like Jonathan Sumption, for example, who has been very critical of the state's actions and just telling us that the state cannot take away our liberties, cannot treat us like children. And on the other hand, we have a vast majority of people who believe that in fact the United Kingdom and many other countries have breached our rights to life by not being sufficiently prepared or being perfectly organized in the way that they have operated this pandemic response. And you see these different views coming in different ways. Now, if you are to take a human rights framework, you'll see that you can't go in either of those polar opposite directions. You have to do something that is about balancing and about bringing people together in a negotiated, balanced way between these two different conceptions of what human rights are there to protect. So that is the first sort of framing idea. That's what human rights require us to do in this context. So to start off, let me just give you a more political context as well. This pandemic has happened at a time when human rights are at threat globally. There is a growing illiberalism across the world, and we have seen that there is a tendency amongst state actors to try and consolidate executive power. And we've seen this all over the world, not only in jurisdictions where we might expect this, in undemocratic jurisdictions, but also in more democratic jurisdictions more recently. We've seen the rise of what many refer to as autocratic populism. And it's in this context that the COVID-19 pandemic has entered, and it has brought up a whole series of threats. And one of the greatest threats that we have is that this emergency context, where the state is operating at such high levels of invasion of our negative human rights, is one that may consolidate executive power and, in what we refer to in the literature as, become normalized. And this is a problem that we see, for example, in Hungary, where the state has taken this opportunity to effectively run the executive by decree. And this is the kind of context that we want to avoid. And many jurisdictions will do different things. That's why in our report we have a variety of jurisdictions which we report on. I will send the link to the comments box. I'm sure St. Anne's will actually post a link now on the page to our report. But effectively we've chosen a series of different jurisdictions with different facets and cultures and democratic and undemocratic cultures. So the first thing to say is that whatever we do in a pandemic context, a human rights response would require us to make sure that the pandemic emergency responses are what we call impermanent, that there is a time limit and duration limit on the kinds of measures that can continue to exist. And that's particularly important in where these measures are particularly exceptional to normal times. So we have to keep these ideas of a pandemic response very much in a temporal constraint, and also to see them as exceptional measures. And we must keep them exceptional in our minds. We mustn't allow them to become normalized in our psychology and our social imaginary. And the second two elements that we require in a human rights context is that human rights are based on two fundamental principles. That the emergency responses are both fulfilling the principle of legality, that is the rule of law, and I'll come back to that later, and they are fulfilling the principle of necessity. That is, that these principles have to be seen as absolutely necessary to justify the framework that they are operating in. So we are commonly referred to necessity as the principle of proportionality, that the ends justify the means, or there are other ways to think about that. So two principles in the human rights context, that they are both legally sound, that they fulfill the idea of the rule of law, and also that they are absolutely necessary. Now, in the context of fulfilling the right to life, we tend to require the state to have acted where it knew or ought to have known of the risk to life of its population. And so in a pandemic context, scientific knowledge and risk become very, very central to the way that state action may or may not be compliant with positive obligations. And so when we see that these two conceptions come together, we see that the state might run an argument to say that the right to life is so important as to blind out all these other rights. On the other hand, we can see that oppositional actors would argue that liberty is more important than these general, what we see as nanny state interventions. So striking an appropriate balance between these positive obligations and countervailing negative rights in this rapidly evolving environment can only be successfully achieved if we have an environment of democratic, judicial, and scientific contestation. What's very important is that this discussion does not become partisan, because what we can only do in a human rights context is seek those solutions that can allow us to have a rational discussion, which is transparent, which is sound, in which many, many voices can come together in a contestation, and in which we can think about how to make these decisions, in a sense, independent of partisan political influence. The final principle that we might want to apply when thinking about these is the general principle of the least restrictive means. Now, least restrictive means principle is a very common idea in human rights. But what we want to do here is make sure that the way that we avert risks to life, or the way that we construct emergency measures with respect to COVID-19 pandemics, is as minimal as possible to achieve the objective of protecting life. So that may mean, and it certainly does in my view mean, that we cannot rely on unlimited exceptional measures without exploring alternative principles, alternative policies that may be less restrictive. And that is why it is incumbent on the state on a daily basis, in fact, in an hourly basis, to consider scientific knowledge, to consider ways in which we might release society at large from more general prohibitions on freedom of movement, in order to ensure that we have a response to this pandemic which is sensitive and is not oppressive without justification. Now, you'll see in the introduction to this report that there is an increasing amount of international human rights guidance and regional human rights guidance coming out of various bodies. Human rights organizations are particularly concerned with the idea that these exceptional measures, these derogations, will become normalized and become tacit to the way that democracies and other states continue to exist. And here, the Office of the United Nations Office of the Commission of Human Rights has set out very simple framework. And essentially it says COVID-19 measures must be proportionate to the evaluated risk, necessary and applied in a non-discriminatory way. And that's a very important principle to ensure that we apply the questions that some of these measures may have a very strong impact on certain sections of the population, and we have to take that into account. So it needs to be non-discriminatory. The measures must be used for legitimate public health goals, rather than as a mechanism to quash broader political dissent. That governments are transparent and public about the nature and duration of the emergency measures, and that emergency measures are finite and viewed as exceptional. At the same time, governments are required to be especially vigilant in protecting the rights of older persons, women, indigenous people, minorities, people in detention and institutions, migrants, displaced people, and refugees. They are enjoined to mitigate social and economic impacts, ensure food security, water and sanitation, protect against stigmatization, xenophobia and racism, while also keeping the public informed and ensuring their democratic participation and rights to privacy. Now, none of these objectives can be met without key accountability mechanisms being in place, both democratic, legal, and intra-executive. So, what are the trends that we've seen in the report coming out? What are the potential threats? Well, the first threat is the threat of a downgrading in democratic accountability, which we've seen across the 11 jurisdictions that we have chosen. And in many cases, that's for practical reasons. So we've seen that there is more use of virtual democracy, and that in some ways limits the way that democratic frameworks can operate in practice, because people can't come together in their parliamentary chambers. But we've seen an interesting range of ways in which democratic debate has been downgraded in the normal course of things. And certainly in Hong Kong, the Emergency Regulations Ordinance has effectively consolidated executive power over pandemic policy and evaded parliamentary response. We've seen some legislatures being deferential, overly deferential to governments. In South Africa, that was initially the case. And we've also seen the suspension of Parliament, which we saw in Australia, normal sittings of Parliament being suspended, and also in Zimbabwe. Now, what that tells us is that although there are some jurisdictions in our report which are continuing to use novel virtual democracy frameworks, and particularly the United Kingdom, but others as well, what it does tell us is that we need specific novel parliamentary institutions to be developed to counter the potential downgrading in normal democratic processes. So we see new types of mechanisms. In New Zealand, we see the Epidemic Response Committee, for example, which is particularly focused on these questions, and we see a greater use of select committees in Parliament in the United Kingdom. But there are calls for the United Kingdom Lords Liaison Committee for a COVID-19 committee, which I think is important, and I think we should be listening and thinking more about how to build those up. Of course, the more that we could go back to normality and to normal democratic process, the better. The second element that we are concerned about is what we call legal accountability. Now, legal accountability is essential to rule of law compliance, and particularly imperative that courts remain open for business and that courts remain vigilant with respect to the way that they are treating the applications that are being brought to courts. And we've seen a variation across jurisdictions with respect to how well the courts are operating. Now, those courts that stay open, we've been particularly watching how deferential they've been to the executive in these contexts, and that is a worry from a human rights perspective, that courts may be slow to criticize. But we have seen examples of where this hasn't happened, and I think this is going to be a rolling question. Now, some jurisdictions have closed courts. Hong Kong has closed courts, and we are particularly worried about jurisdictions where the pandemic responses have been made immune to judicial review, and we see this as a particularly egregious problem. Another issue with respect to legal accountability is not just the mechanisms of the courts themselves, but it's also the way in which the rules of a pandemic are framed. And this is a particularly urgent question. Where rules are framed in very open-ended ways, we have concerns about the possibility of misinterpretation, of over-policing. We see in the UK a debate raging today on whether or not Dominic Cummings was acting within the rules. So the way that rules are framed and the way that they are processed is also part of the legal accountability mechanism. And a third element that we found very disturbing in terms of legal accountability was when actions of security forces or police forces were made immune to challenge. And this was in the example of South Africa, where there's a broad indemnification of executive action undertaken in response to the pandemic. And that in turn undermines the principle of effective remedy and of judicial accountability. Now, it's quite clear that all human rights are implicated if you cannot bring an action in the court, or if your state actors are indemnified from actions and judicial proceedings, and this is particularly concerning to us. A final element that we looked at in terms of accountability structures was whether or not states had intra-executive accountability mechanisms, and these are ways to inject accountability structures inside the executive. We see an example of this in South Africa. The COVID-19 judge has been created to oversee the way in which data is developed and used for track and tracing systems and software. And this is particularly important, that we have intra-executive mechanisms that can oversee regulations, as well as operating alongside the courts. And those intra-executive mechanisms have to do two things. The one is they have to be utterly independent of departmental actors with respect to policy building, so that they can operate as critical actors within the state. And this is a very effective and efficient way of creating accountability. But they also have to ensure that they are transparent. State activity has to be transparent. This is a particular concern with scientific knowledge and the way that scientific committees are drawing conclusions, what their data is based on, and how they are populated, who belongs to them. These are issues that are important in a pandemic context, which we must not ignore. So finally, we see a general use also of an overuse in some jurisdictions, Russia, South Africa, Zimbabwe, Singapore, of the criminal law, and there is a tendency to criminalize breaches of regulations, or criminalize or create novel new offenses, like the spreading of fake news has become a novel new offense under these contexts. And the way that those offenses are framed, their breadth, and whether or not the penalties are proportionate to the objective of criminalization, we need to keep a careful eye on this. One of the important principles of least restrictive means, what we might call the ultima ratio principle, is that we render the criminal law as a mechanism of last resort. So an overuse of criminal law and an overuse of very onerous penalties is something that raises human rights concerns, and we've noted this in our report across a variety of jurisdictions. Of course, the biggest threat going forward to human rights, in our view, one of the biggest threats, is going to be to privacy and to data protection, as states are required to find ways to track and trace while they open up society and open up markets. And so the way in which tracking and tracing and data is used is going to be something that all human rights organizations will be particularly involved in observing. And don't forget that privacy rights underpin many other rights: freedom of association, freedom of expression, the way that political organization operates. Privacy rights have to be upheld in order for other rights to be upheld. They cannot be distinguished or disentangled that easily from protection of privacy and data. And so we note that it's important that there are structures of oversight, similarly to the COVID-19 judge in South Africa, that there are structures of oversight and that there are restrictions on the departments that can use this data, so that the data is only held for the time that it is necessary to deal with the pandemic, and that the data is held in trust and in a framework of accountability which is independent of broader executive objectives. Now we're starting to hear reports today I read a report on China and a Chinese city wanting to use the track and trace technology to create a general health regulation system. And this is something we may be concerned about, because it isn't legitimate, in our view, for a track and trace data collection system to then morph into a broader system of health regulation or of monitoring of individuals in ways that may prejudice their privacy rights or their autonomy. And finally, on the other side of the spectrum, we've seen a particular problem with respect to the protection of socioeconomic rights in jurisdictions where there is not insufficient ability to counteract the economic downsides of lockdown frameworks. And so this has been a particular problem in South Africa and in India, and there have been, even our reporter on the UK has held up concerns with respect to the right to food. So here we have a real dilemma, because of course the right to health and the right to life are socioeconomic rights, but where there are big and oppressive lockdowns restricting economic activity, where unemployment increases exponentially, and where there is a lack of access to basic necessities such as food, these have their own right to health and right to life implications. So that process of managing these different rights objectives is one which has to be carefully assessed, and certainly is one which would be we need to keep a close eye on in respect of how it is distributed, how these burdens are distributed across society, how many people are being undermined in this process. So the poor are disproportionately affected by the kinds of restrictions that we are seeing. And without countervailing measures which attempt to ameliorate the impact of the lockdown, it is simply the case that there is the potential for violations of socioeconomic rights on a broad and dramatic scale. Now, I said finally, but actually there is one more point to make. Even the best legal frameworks that have been put in place will be undermined by excessive policing. General reliance on broad regulatory discretion in the COVID-19 context has only exacerbated this problem. The most alarming trend and the source of the greatest human rights concerns rests in the way in which COVID-19 measures have been enforced by police and military in certain jurisdictions. And in India, our reporter speaks of human rights overreach through implementation, with an excessive use of force being used by police and insufficient inbuilt mechanisms of police oversight. In Hong Kong, the report notes that police appear to be taking advantage of new regulations for political ends and exercising excess force. In South Africa, there are widespread reports of excessive enforcement of the lockdown and other measures by the police and armed forces. And even in the UK, the coexistence of non-binding advice and legislation regulations have arguably led to an overuse of discretionary powers by police officers. So these are just a few examples of a growing trend globally of overuse of policing and security powers, indicating that states in these conditions have urgently to implement training and human rights and training and sensitive policing training to allow for adequate resourcing of policing structures dealing with these dramatic circumstances. So those are the main headlines that we focused in on the report. I've had to summarize a 125-page report for you in a short period of time, but I'm hoping that we can now move over to questions that I can answer in a more discursive way with you, my viewers here. I can see there are 26 of you at the moment, but so please do send in questions. I'm seeing here one with regard to democratic accountability. Have you any example of this being enhanced rather than downgraded by our COVID-19 responses? For example, innovative use of technology to communicate with or consult the population. So we haven't got specific examples on consulting with the population, but we have in the report created tables in the executive summary where we show best practices and we show concerns. So I would imagine in terms of how we would view this, that the way in which the kinds of press conferences we're seeing, daily press conferences in the UK, or even the way that the Prime Minister of New Zealand has been dealing with her population, that the way that communication operates would be a particularly important result of this COVID-19 process. But as we develop that report, we will take more effective note of that. So thank you very much for that question. And here is a pre-submitted question. What one issue concerns you most as a result of possible precedents being set during the pandemic? I think if I was to isolate out the primary issue, to be honest with you, it would be partisan use of scientific information. So I think this is the biggest challenge, not only in respect of the way that the current area is playing out, but I think that the way in which expert knowledge is being gamed for different political advantages is going to run riot structurally with the capacity for states to think about how to balance scientific knowledge, scientific risk with individual liberties. Because now what we are in is a meta debate about the truth statements of the scientific knowledge, and we're seeing extraordinary attempts by politically partisan actors who wish to question the credibility of scientific evidence. And we see this in examples of documentaries like Plandemic. So there is a particularly worrying state of affairs at the moment where conspiracy theories from all sides are being pushed, and so my greatest fear is that the foundations of political debate are being eroded now by the gaming of particular scientific knowledge, and they become very sophisticated, these conspiracy videos, where they draw on one particular scientist, call that scientist the greatest scientist ever living, the Nobel Prize winning. And in a population that does not understand, the broad majority of a population that wishes to be democratically involved cannot scrutinize the broad framework of scientific knowledge. It needs to be transparently and rigorously presented in a democratic framework. And that, in my view, is the greatest problem, that we have to build structures of democratic dialogue in which science can be contested and discussed without there being a threat about what statistic may or may not increase or decrease a particular political position. Right, and I have another question here. Maybe too early for this, but I would be interested to know whether any work has been done yet to review and assess and compare countries' human rights responses against the death toll in those countries. If not, do you have any predictions as to how that might look? I don't have any predictions on this, and I also have to say that we particularly did not choose to look at the quality of whether or not one country was doing better than another in respect of death tolls. However, what I will say to you is that death tolls have implications for the way in which the right to life may or may not be violated by a state. So there is a question hanging over what kind of inquiry might be operating where states have actively refused to follow scientific advice or refused to think through the risks to life that are in play. And Article 2 of the European Convention of Human Rights protects the right to life, and many other human rights documents internationally protect the right to life, and they require states to act where they knew or ought to have known of the risks placed. So in that respect, the chances are that countries with very high death tolls relative, or per capita death tolls relative to their own population, especially those that have the means and the capacity to have responded adequately, will be under greater scrutiny when the courts or the European Court of Human Rights or other institutions assess compliance with the right to life. And again, that comes back to this question of how rigorous the scientific knowledge is and how well it's presented in a democratic context. Another question: how do we balance the need for transparency about sources of information and advice with the need to protect scientists from being bullied? Absolutely brilliant question. I don't know the exact answer to this. I saw the most horrifying photographs today from the German scientific advisor on this. They're receiving these terrible vials of whatever they are, saying drink this, you will be immune, with a positive sticker on them. These are death threats that are happening. So I think that one of the reasons this is happening is because it's not safe to be transparent. I think one of the reasons it's happening is because science has become hyper-politicized, and that is why I see that as the most foundational difficulty. It's a particular difficulty for people in our profession, in any academic profession, where we're not left to give the best scientific response, but instead of being influenced or pulled one direction or another. And you see this in the United States and in a variety of jurisdictions where scientists are being forced to take certain types of positions. So I agree that the transparency question is a question that is nuanced, because it's in a context that where a political environment needs to know that we are not seeing some kind of political attempt to discredit and to undermine the base scientific operation. One of the things that democracies tend not to know about any scientific contestation is that it's constantly a process of contestation, and so it's always being refined, it's always being analyzed. So that's the difficulty. The other difficulty is that politicians hide behind what they call the science to avoid political accountability to their electorate. So this is a very vexed question. Hi Jack, a question from you. In addition to nation states' response measures, do you have any thoughts on how supranational bodies' approach to protecting human rights might be affected in the longer run by current events, to some degree forcing the world back into nation states acting independently of one another? So our report doesn't deal with this question of how international organizations may or may not be undermined in this context. But there is no question that the way in which the pandemic has played into pre-existing nationalisms, pre-existing attempts to discredit international organizations, to undermine international organizations and their functioning, and to undermine a multilateral approach to solving global activities. This has certainly exacerbated these pre-existing tendencies. But I can tell you, this was not, human rights organizations were under some very, very difficult tensions and pressures already. There's no question that human rights organizations, the United Nations, have been discredited by the Trump regime, and the European Court of Human Rights is facing tremendous pressure from the United Kingdom, and has been for a very long time, from various sectors of the right in the United Kingdom. So this is a pre-existing problem, and I see this as another species of this bigger problem. Right. Are there any suggestions you would make to countries' governments to further protect human rights in the case of a future crisis or pandemic? Yes, I would make one suggestion, which is that I would evaluate all of the information you have about future risk. So we know that in companies or in charities like our own, we have risk registers which include pandemics. And we know, for example, in the United Kingdom, that there has been plenty of warnings in respect to readiness to deal with a pandemic. What you need for a crisis is for a state to think calmly in an environment where there is no crisis, and work through all of the different variables. The vast difference between countries that were pre-prepared for the pandemic, that acted quickly and preemptively and smartly with respect to the way that it dealt with track and tracing, is, in my view, enormous. And I think that it has huge human rights implications, not only for the realization of the right to life and the right to health, but also for the way in which the liberties have been restricted. So what you tend to see is very extreme lockdowns in countries that are hideously unprepared, which have very low health frameworks. So the biggest advice I'd give would be pre-preparedness, but that can also come simply by being committed to the right to health in a general way, and for understanding how the health system and resources into a health system would operate in order to ensure that this kind of pandemic is not as earth-shattering as it has been. So I'm still waiting for questions here. Not seeing any more. So let me just say, an objective, a human rights objective is, and please do send in questions while I talk here. A human rights objective is really to try and find the most careful, granular, and nuanced balance between competing rights, because we have to see all of these rights as indivisible. So we have to see how the right to life can be realized, while at the same time restrictions on liberty, freedom of expression, privacy, all of those kinds of rights are not undermined to the point that they are non-existent. So my view is that democratic discourse has to underpin that discussion. It has to be able to say in an honest way that there are always going to be imperfect solutions, but that the way that those solutions are achieved have to be proportionate, necessary, legally sound, democratically contested, and judicially verifiable, scrutinized, as well as effective. And that would be, I think, in a nutshell, what the human rights approach would bring to this discussion. And there is, in my view, little point in trying to achieve the priority or the absolute realization of one right over another. You don't find an easy balance between those two things. So we cannot have ideas that are what I would call sort of monofocal ideas about liberty being absolute against life, or life being absolute against liberty. The whole mechanism of human rights is in the balance, in the nitty-gritty relationship between these different objectives. And that requires, in order for a proportionate solution to be found, you need to find excellent information and clarity about what they are doing. Here's another question. Does the complexity of the lockdown rules put police officers in the front line in difficult positions? How can they be protected? Yes, of course. So the clearer the rules are, the better. Of course, police may view rules in different ways. They may say that rules are too restrictive and they force them to police them too much. Or they may say they are too vague, and which allows for too much variation of practice to go across. So I think that the best rule is one which allows discretion, but structures that discretion in a way which is which allows for some kind of clarity and balance. But the other thing, part of this, is that the police need to be protected through their own frameworks of accountability. They need to be able to say, in a context in which they may be doing something very difficult, and this is not, this varies hugely across jurisdictions, they need to be able to say our accountability mechanisms are robust. We know that we are thinking about how these mistakes may be made. We are sure that the police will be held, the police officers or security officers, army officers may be held accountable. They will be held accountable. And those are the ways that you engender trust, even in extreme policing measures. So yes, I think that the way that rules are framed is a very important part of this, but so is the culture of the police, and so the accountability structures of the police in those frameworks. So I think, short of any more questions, which I'm happy to answer, I'm also happy to take any further queries by email directly from viewers. But I do recommend reading the report, having a look at the different ways in which these countries have responded. You'll see some rather interesting counterintuitive responses by some countries, and I think that one of the other final points I want to make is that the way in which we measure proportionality and the necessity of a measure is a changing feast, because it has to be framed in ways that we can assess, and in each day new information will arise, and it will change the balance between how states ought to act once that new information or that new resource arrives. Anyway, thank you very much to everybody. And how did we select the 11 countries? We selected countries that had vastly different contexts. So we chose a couple of European, UK, Germany, Italy, in Europe. We chose global south countries such as the South Africa and India, which we saw was very useful, thinking about these countries that have vast disparities of wealth. We chose countries in Southeast Asia. We've got Singapore and Hong Kong. So we chose Commonwealth countries as well. So we chose kind of samples. The area which we didn't cover, mainly because we weren't in a position to do so with the people we had at the time, but we are supplementing the report as we go along, are the Americas. So we don't have enough there on America, but we will be building that framework. So it's a lot to do with getting the report out quickly and having people available with the expertise to do it. Great. Well, I think I see no further questions, and I'm starting to cough, which is also a sign. So I will say good night to all of you, and thank you very, very much for listening. Thank you.